coming to New Hampshire, to Gorham, to cover this case as some of the gruesome details came out. And we are hearing many of those details right now live from the Belknap County Superior Courthouse. What you're looking at right now is Nathaniel Kibby, the defendant, as a conference is taking place. Once again, we want to let you know that we are following live breaking news on NH1 and NH1 99.1 New Hampshire's News Radio. The case against Nathaniel Kibby, he's the Gorham man accused of kidnapping a Conway teen back in October of 2013 and sexually assaulting her over a 9-month period. The hearing, again, being held at Belknap County Superior Court in Laconia. We will be, once again, listening in live right now. There is a conference going on with the judge, but Associate Attorney General Jane Young had been giving testimony of all of the events that ultimately led up to the arrest of Nathaniel Kibby, and she is detailing in detail, in extreme detail, excruciating detail in many cases, some of the just horrific acts that Nathaniel Kibby is guilty of performing on the victim, a 14-year-old at the time of her kidnap, who we are not identifying because of her age. Any references to the victim will be AH. That is how we will refer in any time that Associate Attorney General Jane Young does opt to mention the name during her testimony. We will drop the audio portion. So if you happen to be listening or watching and wondering why suddenly the audio portion disappears, it is because the victim's name has been used. The victim and her family are in the courtroom right now as well at the Belknap County Superior Court.
We have NH1's Colleen Shaughnessy sitting in the courtroom, and she has been keeping tabs on this story. You can follow her on Twitter, and some of her tweets are really giving a lot of detail and perspective to this case. It all started in October of 2013. Of course, as Charlie had mentioned, the victim did not know Mr. Nathaniel Kibby before this all took place. She was on her way to work, it appears, and she was offered a ride by Kibby, accepted that ride, got into the car, and that's when things literally took a turn for the worse. He brought her to a parking lot and was making threats to her. The defendant pulled back a black handgun on the victim, threatened to shoot her, handcuffed, and put a ball cap on her. And now we're going to be listening back into Jane Young giving us the rest of this testimony.
With purchase records, physical evidence found at the defendant's home, including the victim's DNA. Statements of witnesses also corroborated, and in fact, the defendant's own words in jail calls corroborate the victim's statement. I would note that I was given a note indicating that when the defendant explained about the bag, how it burns, he did not demonstrate by placing it on fire. Your Honor, evidence was sent in this case to the New Hampshire State Lab, to the Secret Service, and to outside labs, which again all corroborated the details that the victim would have testified to about her kidnap, sexual assaults, and criminal threatenings. Those are the facts, Your Honor, we would have relied on had this matter gone to trial.
Thank you, Ms. Young. What are the terms of the plea agreement?
Your Honor, in return for the defendant's pleas of guilty, the state would make the following recommendations. On charge number 1169104C, which is aggravated felonious sexual assault, he would be sentenced to the New Hampshire State Prison for not more than 20 years, nor less than 10 years. Stand committed commencing today. He would be given pretrial confinement credit of 669 days. The court is asked to recommend to the Department of Corrections sexual offender program. Other conditions are he's to participate meaningfully and complete any counseling, treatment, and educational programs as directed by the correctional authority, subject to the provisions of RSA 651A 22A. The Department of Corrections shall have the authority to award the defendant earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. The defendant and the state have waived sentence review. The defendant is ordered to be of good behavior and comply with all terms of the sentence, and then there is an addendum. So all the other sentences, Your Honor, have the same conditions. It's just the time. On the next one, which is 1169103C, he would be sentenced to 10 to 20 years at the state prison, stand committed, consecutive to the first charge. ID number 1169106C, he would be sentenced to the New Hampshire State Prison for not more than 20 nor less than 10 years, stand committed. Again, that would be consecutive to the first two. 1020546C, he would be sentenced to the New Hampshire State Prison for not more than 10 years nor less than 5 years. That would also be stand committed. That would be consecutive to the other three sentences. Charge ID 1020576C, he would be sentenced to the New Hampshire State Prison for not more than 7 years nor less than 3.5. That would be stand committed, consecutive to the other ones. 1020557C, he would be sentenced to the New Hampshire State Prison for not more than 7 years nor less than 3.5 years. That would be consecutive, Your Honor, to the other 5 charges. And on the last charge, Your Honor, that being 1020548C, he would be sentenced to the New Hampshire State Prison for not more than 6 years nor less than 3 years, stand committed. That, Your Honor, would be a stand committed sentence of, by my calculations, 45 to 90 years. The sentencing addendum would be in the event that he files a petition pursuant to RSA 65120, or after having served 2/3 of the aggregate minimum of his sentence. If he moves to suspend his sentence, the state will not summarily object, but would consider such petition on its merits. The state will recommend that the defendant be housed at a correctional facility outside of the state of New Hampshire. Number 3, the state will request that the United States Attorney's Office not pursue any federal charges against the defendant. And 4, the defendant will reveal the location of several ounces of marijuana in exchange for the state's agreement not to bring charges for that offense. I can represent to the court on the record that my colleagues have spoken with representatives from the United States Attorney's Office, and they have indicated that they will not bring charges in any regard to the defendant's criminal enterprise for which he is here today, the kidnapping, the sexual assault, the threatening, or the physical assaults, or the counterfeiting.
Is that contingent on the plea?
It is contingent on the plea, and we have been told that we would have something in writing tomorrow that we would be able to give to the defendant, but we wanted this to go forward today, so we have the ability to put this on the record.
Okay.
I will also tell the court that I have spoken with the victim and the victim's mother about this sentence, and they are in agreement.
Okay, thank you.
Thank you.
And one other thing for the record, the defendant is offering pleas on 7 indictments. Obviously, there were more, 182 of them, as I understand it. And I just want to confirm for the record what's implicit, that the remaining indictments would be no cost.
They are, and that includes one indictment, Your Honor, that has been severed and is not here, which is the forgery, which is in Coos County, but that will also be. Yes, this is a global resolution to all the charges.
Okay. Thank you, Ms. Moore.
Thank you, Your Honor.
Of course.
You are watching live coverage of Nathaniel Kibby in court in Belknap County Superior Court in Laconia. He has changed his plea from not guilty to guilty, and he is pleading guilty to 7 indictments. Let's go back live to the courtroom.
Understanding and admitting to those elements, and understands that the state can meet their burden of proof with respect to the elements of those 7 charges and can prove them beyond a reasonable doubt. As to the 175 charges, actually 176, I believe that are being no loss. He in no way is admitting to the underlying behaviors as the state's offer had just suggested. In fairness to me, we believe that if the case were to go forward to trial, some of the factual assertions that the state has put forward would not necessarily be able to be proven. This in no way should negate whatsoever the fact that he's here before the court today to take full responsibility for the 7 charges that are subject to this proceeding.
Okay, so you're not taking exception to the offer of proof as they pertain to the 7 charges, as the offer pertains to the 7 charges for which the pleas are being offered?
Correct.
Okay. And is that your understanding of the terms of the plea agreement?
It is.
Mr. Kibby, is that your understanding of the sentences that you would be required to serve in exchange for your pleas of guilty?
It is.
Your form indicates that you have some college,
Yes.
so you read and write English,
Yes.
and you understand what you read.
Yes.
Did you read the acknowledgement and waiver of rights form completely?
I had it read to me, yes.
Okay, did you understand it when it was being read to you?
I did.
After it was read to you, did your attorneys explain it to you in detail?
Yes, and I answered any questions.
And you understood what they told you?
Yes,
And you had questions that they answered to your satisfaction?
they did.
Do you have any questions of me about anything in the form or anything at all concerning your rights, these proceedings, or what may happen to you as a result of these pleas?
I do not.
Attorney Friedman, you went over the acknowledgement and waiver of rights form with your client?
With Attorney Schwartz.
Okay, and your colleagues went over with him each right that he's waiving today?
Yes.
And all parts of the form as it relates to these particular pleas?
Yes.
Did you go over with your client the elements of the offenses with which he's charged?
We did.
The burden of proof of the state?
Yes.
The possible defenses he may have?
Yes.
The legality or admissibility of any statements, confessions, or any other evidence in the possession of the state?
In depth.
To the best of your ability, do you believe that Mr. Kibby is knowingly, intelligently, and voluntarily waiving his rights and pleading guilty?
Yes.
Mr. Kibby, you understand that by pleading guilty, you are giving up certain constitutional rights to which you're otherwise entitled. Among these rights are the right to a speedy and public trial by jury, the right to see and hear the evidence and cross-examine the witnesses against you, the right to the process of this court to compel the attendance of witnesses in your favor, the right to continue to be represented by your attorneys at all stages of the proceedings, including trial if you decide to have a trial, and your right to an appeal if you're convicted. Do you understand that by pleading guilty, you're giving up each and every one of these rights?
I do, Your Honor.
Do you understand that you're presumed to be innocent? The state has to prove that you're guilty. You do not have to prove that you're innocent.
I do.
And you understand that in proving your guilt, the state has to do so using competent evidence beyond a reasonable doubt.
I do.
Do you understand that if you had a trial, you would not be required to testify?
I do.
And if you decided not to testify, the jury would not be able to use that as evidence that you're guilty?
Yes.
Do you understand that if you had a trial, you could only be convicted if all 12 members of the jury unanimously agree that you're guilty? In other words, if one member of the jury is not convinced of your guilt, you could not be convicted. Do you understand that?
Yes.
Having all these rights in mind, is it still your desire to give up these rights and plead guilty without having a trial?
It is.
Are you satisfied with the services rendered to you by your attorneys?
Throughout this plea negotiation, yes, I am.
And you have told them the whole story without withholding anything from them?
I have.
And they've gone over the charges and the possible defenses you may have?
We have.
You understand that you're accused of 3 counts of aggravated felonious sexual assault, alleging patterns, 1 count of kidnapping, 1 count of criminal threatening, 1 count of witness tampering, and 1 count of second-degree assault.
I do.
And your attorneys have gone over with you the definition of those crimes?
They have.
And have they broken down the definitions into their elements?
Yes, they have.
You know what I mean by the elements of the crime?
Mens rea, you mean?
Well, including the mens rea. In other words, for the aggravated felonious sexual assault,
Actus rea?
Yes, that too. They have to prove that you engaged in more than one act of sexual penetration over a specified period of time, what the act of penetration was, and that you acted knowingly. And the other element with respect to lack of consent and so forth. You understand what I mean by the elements now?
Yes.
And you understand that in order for you to be convicted on each of these indictments, the state has to prove each and every element of the crime charged in that indictment beyond a reasonable doubt.
Yes.
Are you pleading guilty to these charges because you admit that you committed the acts set forth in the indictments and intended to do so?
Yes.
Have you been advised as to the maximum penalty provided by law for these offenses?
Yes.
For the aggravated felonious sexual assaults, what is the maximum that you can get?
10 to 20, $4,000 fine.
And for the kidnapping?
7.5 to 15, $4,000 fine.
And for the Class B felonies?
3.5 to 7, $4,000 fine.
Anyone make any threats against you, any member of your family, or anyone near and dear to you in order to compel you to plead guilty?
No.
Other than this plea agreement, has anyone promised you anything or offered you any inducement whatsoever in order to persuade you to plead guilty?
No.
Are your pleas of guilty entirely free and voluntary?
They are.
Are you presently under a doctor's care for anything?
I am not.
Do you take any medication or drugs on a regular basis?
I do not.
Have you taken any medication, drugs, or alcohol today?
I have not.
Attorney Friedman, have you noticed anything in your conversations with your client or your observations of him today that would indicate to you that he's consumed any medication, drug, or other substance that may affect his judgment?
No.
I will accept your pleas. Do you waive the reading of the indictments?
Yes.
Mr. Kibby, on indictment 116910-3C, accusing you of pattern aggravated felonious sexual assault involving cunnilingus. How do you plead, guilty or not guilty?
Guilty, Your Honor.
Indictment 116910-4C, pattern aggravated.
Once again, you are watching the trial or the sentencing of Nathaniel Kibby. This is breaking news. Nathaniel Kibby, the Agora man accused of kidnapping a Conway teen back in October of 2013 and sexually assaulting her over a 9-month period. The hearing is being held today in Belknap County Superior Court because Mr. Kibby has decided to change his plea from not guilty to guilty, negotiating down from 182 indictments down to 7. Let's go back to the courtroom. A little conference going on between Attorney Freeman, who is the lead defense attorney for Nathaniel Kibby, and we are just waiting for the audio to resume in the courtroom.
Part of the plea deal, we're understanding 45 to 90 years for all of those 7 indictments that he's now pleading guilty to. And part of that deal means no federal charges, and to help locate some marijuana that he might have in his home, which is one of the ways he was drugging this woman. Let's now listen back in.
Guilty, Your Honor.
1020548C, criminal threatening, guilty or not guilty?
Guilty, Your Honor.
One 1020557C, witness tampering, guilty or not guilty?
Guilty, Your Honor.
And 1020576C, as it's been amended, second-degree assault, guilty or not guilty?
Guilty.
Court, having questioned the defendant and his counsel on the offer of his pleas of guilty, the defendant and his counsel having advised the court that they have conferred concerning the offered pleas and all aspects of the charges against the defendant and any defenses he may have, and the court having observed the defendant making his answers, his demeanor or manner while answering the questions, his apparent intelligence and attitude, and the court having observed that the defendant does not appear to be under the influence of any medicine, drug, or other substance that may affect his judgment in any manner, the court finds that the offer of the pleas of guilty of the defendant to the indictments have a factual basis, are free of any coercive influence of any kind, are competently and voluntarily made with full knowledge of the charges against him and the consequences of his pleas, that no promises have been made to him by anyone, and no threats or coercion have been exerted upon him in any manner. It is hereby ordered that the pleas of guilty of the defendant to the indictments be accepted and entered. And you may be seated for the moment. Ms. Young, I will hear the state on the issue of sentencing and the reasonableness of the negotiated disposition.
Your Honor, the state came to this recommendation of 45 to 90 years because it's firm belief for all intents and purposes it's a light sentence for this defendant. The victim in this case was traumatized for 9.5 months. To put her through a trial, we talked about that, and we believe that this was what was best for the victim in this case. The state was prepared and ready to go to trial. It's the state's firm belief that we would have proved each of those charges beyond a reasonable doubt. But to save the victim the embarrassment to have to testify as to what that monster did to her for 9.5 months, this is a reasonable sentence. And so for that reason, we are asking the court to sentence him to that. It deters other people from, God forbid, ever doing something. It punishes him, and in our belief, he's never going to step foot in society again to hurt this victim or anybody else.
Is there going to be a victim statement, or?
Yes, would you like that now?
This is the time.
Right now, you're looking at Nathaniel Kibby. We will do impact statements. We will not show the victim's face.
I'm sorry.
Is it?
It's not amplifying. It's just recording.
Okay.
Yes, if you, perhaps if, well, I think that just records. It might amplify. Let me check.
Okay, I can just talk loud. Yeah. Okay, so I was told that I would have to give a victim impact statement and that I would have my time in court to talk. It seems like forever. 2 years have gone by, both fast and slow in different senses. But I often think about Kibby, and what he did affects my life on a day-to-day basis. My name does not mean the same thing anymore that it did before October 9th. I'm attending school, and I'm afraid to let anybody know what my last name is. Nobody knows what my last name is. I fall asleep thinking about you, and Some people might call you a monster, but I've always looked at you as human. And I want you to know that even though life became a lot harder after that, that I still forgive you. That I wish things didn't have to work in the way that they do. But I need to be safe, and so does my family. And I want you to know that I did not do this to you. I did not put you in prison. You put yourself in prison. So I can't carry that blame on my shoulders when it's simply not true that I put you in prison. When you decided to point that gun at me, that was not my choice. It was not my choice to go to your house. It was not my choice for you to rape me. It was not my choice for you to threaten me. You did all that yourself. I don't want to talk down on you, and I hope that you don't think that I am. I'm just telling you the truth. Because sometimes I feel like I wear this whole thing like a millstone around my ankle. Sometimes I still feel like I'm chained, and sometimes I don't feel like I'm completely free. There are certain aspects of my freedom that I can never get back. But in the same aspect, I want you to know that I appreciate my freedom because of you, and that I enjoy and appreciate life because of you, and that I never look at sunshine in the same way. And that I never think about fresh air in the same way. So, and I also just want to thank you for giving me my freedom back.
Could you just state your name?
My name is Xenia.
Well, you just heard victim statement from the victim, an incredibly brave young woman in her victim statement forgiving Nathaniel Kibby. We are awaiting the victim's mother, who will now be making a statement as well. You are looking at Nathaniel Kibby behind his attorney, that's Attorney Freeman, in front. Nathaniel Kibby in the middle of his three attorneys who are representing him. He has changed his plea to guilty. He was charged with 182 indictments, and he has pled guilty to 7 indictments.
I did not think I would see my daughter alive again. I don't know. So, and then I saw her. I am being completely honest here, and I thank you for that. I'm thanking you for not killing her, but I should never have to thank you for that. You should have never had to make that decision of basically turning yourself in or that. But at the same time, I still cannot reconcile with what happened. Once I heard it, it still haunts me. It's all I think about. I do not understand why. And I don't know if you want to tell us why. There's a part of me that hates you, and there's a part of me that wants peace, and only you can really explain that I don't understand why. I somehow felt that maybe you're angry and sad, but you took it out on her. You know, instead of fighting whoever did harm to you, you took it out on an innocent person. And I don't know. I wish I could hear from you why. Like, why? Like, the whole thing. And I think about it. It's all I think about. Could you please tell us why you did it?
It's easy to listen to what the state has said and say that he deserves nothing. And Nate's not here asking anybody for anything because he understands that he actually doesn't deserve any of that today. But the decision he made today was a step in knowing that he and everybody else can move forward from today and hopefully have some closure and move on and make the rest of their life. For that reason, he comes before the court. He takes responsibility, and we believe that the structure of the negotiated disposition, as outlined by attorney, is more than sufficient to assuage any concern of the court under the circumstances.
Anything else from the defense?
I can have a minute?
Of course.
Obviously, there's a lot going on in my head right now. I would just like to say that I take responsibility for my actions, and I apologize for what everyone has had to go through as a result of the choices and decisions that I made. And I know that some people want some answers and some closure, and I actually want that too. But I don't really feel comfortable. I don't really have anything don't have the words, I guess, at this moment. But I do think that at some time in the future it would be appropriate for that to occur for all parties. So, if anybody wants to reach out later down the road, I would. I'm also apprehensive about making such comments before the media making a spectacle. I don't think it's appropriate.
Thank you, Mr. Kibby. Anything further?
You're looking live at Nathaniel Kibby, who's now facing 45 to 90 years in prison after he is now pleading guilty to 7 different charges, and they include 3 counts of aggravated felonious sexual assault, criminal threatening, witness tampering. We just heard some very emotional statements from the victim in her impact statement, and in it she explains that she forgives Kibby. She says, quote, "I didn't put you in prison, you put yourself in prison." She also says, "Certain aspects of my freedom I cannot get back." She also says she doesn't look at sunshine the same way, and she thanked him for giving her quote, freedom back. Also some emotional testimony from the victim's mother, who spoke just after her. This all happened when she was 14 years old, trapped and raped by Nathaniel Kibby for 9 whole months at his home in Gorham. The victim's mother saying in her statement she thanked Kibby for not killing her daughter, but noted she shouldn't have to thank him for something like that. And she feels that he took his anger out on the victim her own daughter, who was 14 years old at the time that this all happened. And some of the testimony we heard from the Assistant Attorney General Jane Young, she explains that Nathaniel Kibby had picked her up on the side of the road, asking her if she wanted a ride. She got into the vehicle. He tased her, brought her back to his home. He broke her phone so she couldn't be tracked. And now we'll listen into the judge and learn more.
Is not an inappropriate balance of all the factors that I have to consider under the circumstances, and accordingly, I will accept and impose those sentences. I am just going to say a few things. First and foremost, obviously, or at least it's obvious to me that for these crimes, these are on the lenient end of the range, and I'm sure you understand this, but if you had been convicted of these crimes and perhaps some of the others, these, of course, are only 7. You are facing a lot more. You're going to have an opportunity to be paroled after serving the minimum term of these sentences, and I also understand, and I see, and I'm mindful of the 65122A provision in these sentences as well, which is, again, tilts it a little bit more toward leniency. But I can assure you that if you had been convicted after trial, the 651 A22A provisions would not be in there if I were imposing sentence. I can assure you that if there were more convictions, that they would be, you would be serving time on that. And to put it as directly and bluntly as I can, if you had been convicted of the number of sentences for these crimes that would have allowed it, you would probably not have had the opportunity to see the light of day again in terms of a life outside of incarceration. These sentences give you that opportunity. And the major mitigating factor, and I'm not blind to it because it's why I'm accepting it, is the mitigating factor that the state has articulated, is that you have taken responsibility. That's important. And I think it's important for a reason that I want to make very explicit, although I think it's implicit in the statements you've heard. There is, on occasion, perhaps more occasions, unfortunately, a situation where people who are subject to what you've subjected this particular victim to assume some of the guilt. And I think it's very important for me to state as directly as I can that there is no guilt at all that rests on the shoulders of the victim. None whatsoever. Any guilt in this case is you, nobody else. And by taking responsibility, you have in essence said that, and I think that that is important and something that that needs to be said and needs to be heard by the victim. And also, you have by taking responsibility and pleading guilty, I don't think there's any question that, and I'm understating it when I put it this way, that the victim, a trial in this case would be exceedingly difficult for the victim for legitimate reasons. I would not fault you for that. I would not sentence you for that. I would sentence you for the crime, not for the fact that the process is difficult for the victim, because you have the right to that process, and what you would do in terms of putting the state to its proof is an appropriate use of that process. But the fact that you have taken this step and spared the victim and again, it's an understatement when I use the word difficulty, the difficulties of having to endure a trial, I think is a mitigating circumstance. There's one thing, and it's been alluded to, but I'm going to comment on it, that I am not really considering mitigating. And I mean, it was alluded to in the victim statements that this is not a homicide case. And it's true, it's not a homicide case. On the other hand, most pleas I take are not homicide cases, and I don't consider it mitigating when someone offers a plea to a burglary and I say, well, at least it's not a homicide case. That's not a mitigating circumstance. That takes it to a whole other level. So I do not consider that. Obviously, if it had been a homicide case, we would be in a very different situation, but we're dealing with what we're dealing with. The only other thing, I have used plural on victim because the minor AH is not the only victim. Her family, I think, is a victim as well. What you did is every parent's nightmare, and I don't want to minimize that either. That is I'll leave other people to comment on what that is and what that means, but for my purposes in considering the appropriateness of a sentence, both in terms of a plea or after a trial, the fact that there is all the victims are considered is important. So I want to make that explicit as well. I don't think I really need to say any more at this point. I'm going to consolidate the reading of the sentences to the extent that I can, but they are.
Well, once again, you were watching live coverage of Nathaniel Kibby in Belknap County Superior Court changing his plea. He was facing 182 indictments in the negotiated plea. He has pled guilty to 7 different indictments, and you heard the impact statements. Let's go back to the courtroom one more time.
1169103C, a finding of guilty is entered. You are sentenced to the New Hampshire State Prison for not more than 20 years, nor less than 10 years. On 1169106C, the third aggravated felonious sexual assault, you are sentenced, a finding of guilty is entered. You are sentenced to the New Hampshire State Prison for not more than 20 years, nor less than 10 years. On 1020546C, the kidnapping, a finding of guilty is entered. You are sentenced to the New Hampshire State Prison for not more than 10 years, nor less than 5 years. On 1020576C, the second-degree assault, a finding of guilty is entered. You are sentenced to the New Hampshire State Prison for not more than 7 years, nor less than 3.5 years. On 1020557C, the witness tampering, a finding of guilty is entered. You are sentenced to the New Hampshire State Prison for not more than 7 years, nor less than 3.5 years. On 1020548C, the criminal threatening, a finding of guilty is entered. You are sentenced to the New Hampshire State Prison for not more than 6 years, nor less than 3 years. On all of them, there is added to the minimum sentences a disciplinary period equal to 150 days for each year of the minimum term of your sentences, not to be prorated for any part of the year. These are all stand-committed sentences, and they are all consecutive to each other.
You are watching live coverage of the sentencing of Nathaniel Kibby. Judge Larry Smuckler just announcing the sentences on the 7 indictments that Nathaniel Kibby, you see Nathaniel Kibby there with his attorneys, that Nathaniel Kibby has been sentenced to. He has changed his plea from not guilty to guilty. Let's go back to the courtroom.
Make sure everything is understood, and if you had questions, I wanted to give you a chance to have them clarified. As I said, these sentences are all consecutive to each other. So they, as served consecutively, they sum to 45 to 90 years, 45 minimum, 90 years maximum. On the 1169104 aggravated felonious sexual assault sentence only, not the other ones, you are entitled to 669 days of pretrial confinement credit. On all of them, I am recommending to the Department of Corrections the sex offender treatment program. On all of them, the other conditions of the sentences are that you are to participate meaningfully and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation parole officer, subject to the provisions of RSA 651A 22A. The Department of Corrections shall have the authority to award you earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. I have your written waiver of sentence review. You are ordered to be of good behavior and comply with all the terms of the sentences. And other conditions are that if you file a petition pursuant to RSA 65120, or after having served 2/3 of your aggregate minimum sentence, you move to suspend your sentence. The state has agreed not to summarily object, but would consider any such petition on its merits. Second, the state will recommend that you be housed at a correctional facility outside the state of New Hampshire. Third, the state will request that the United States Attorney's Office not pursue any federal charges against you. And last, you have agreed to reveal the location of several ounces of marijuana in exchange for the state's agreement to refrain from bringing charges for that offense. Do you understand the terms and conditions of your sentences, sir?
I do.
Abby?
Right now, Nathaniel Kibby is signing the forms that complete his plea of guilty to 7 different charges, which will send him to prison for 45 to 90 years on those 7 indictments.
We heard some very emotional testimony from the victim and from her mother, saying in part that they forgive him. They are happy that she was not killed in being held captive and being raped in part of this kidnapping that took place over the course of 9 months when the girl started at 14. Some very, very wild and very uncomfortable details in this case, all outlined in this testimony. It all began in 2013 when the victim was picked up on the side of the road by Nathaniel Kibby. He drove her to a parking lot and tased her, brought her back to his home in Gorham, and that's where over the course of 9 months he broke her phone so she couldn't be tracked. He put a shock collar on her, put tubes in her mouth to make sure she could drink water, put her in diapers, chained her down, raped her, had cameras watching her at all hours of the day, drugged her with sleeping pills, alcohol, and marijuana. And this, of course, some very graphic details. Well, this young girl, 14 years old, of North Conway. This statement from the victim says that she forgives Kibby. She, quote, "I didn't put you in prison, you put yourself in prison." She also said, quote, "certain aspects of my freedom I can't get back." She said she'll never be able to look at sunshine the same way, and thanked him for giving her her, quote, "freedom back." Her mother, also some very emotional and revealing testimony. She said she thanked Kibby for not killing her daughter and said that she feels that Nathaniel Kibby took anger out on her daughter. The judge also saying some things of note. Judge Larry Schmuckler, he says that Nathaniel Kibby has taken responsibility and what he did is every parent's nightmare. He said there's no guilt at all that rests on the shoulders of the victim. This all relies on the shoulders of Nathaniel Kibby. He said, quote, "I don't think there is any question that a trial in this case would have been exceedingly difficult for the victim." Now let's listen into the rest.
Obviously have. I'm not going to sit here and pretend that everything's going to be okay. That would be impossible. But I am in awe of your ability to move forward, and I wish you the best as you do move forward in your life. Okay. If there's anything further to come before the court? Okay. Then this proceeding is completed, and you are remanded to the custody of the sheriff.
All rise. Well, you're looking at Nathaniel Kibby, who is being remanded to the state prison here in New Hampshire, at least for the time being, sentenced to 45 to 90 years in prison. There were actually three. He pled to 7 indictments. There were 182 indictments in all, but in the negotiated plea, he has pled to 7 indictments, 3 of aggravated felonious sexual assault, 1 charge of kidnapping, 1 charge of witness tampering, 1 charge of second-degree assault, and 1 charge of criminal threatening. As Chantel just said, we heard impact statements from the victim, A.H., and her mother. There were federal charges that were pending had he gone to trial, but based on this plea agreement, there will be no federal charges filed. As you watch Nathaniel Kibby being led out of the courtroom by court officers and the New Hampshire State Police.
Kibby gave a statement himself. He said some people want answers and closure. He said that he has no words, and he said, quote, he does not want to talk in front of media and make a, quote, spectacle. So a lot of really emotional things coming out of that testimony that lasted over an hour. We now know great detail about what happened 9 months time in that Gorham home of Nathaniel Kibby. And
horrific details. Jane Young, the Associate Attorney General, going over bit by bit all of the details of that 9-month period, and in couple of occasions referring to Nathaniel Kibby as a monster. Interestingly enough, Kibby showing virtually no emotion during all of the testimony, the victim statements, and the comments from Judge Larry Smuckler.
And it all ended with Judge Larry Smuckler saying, quote, "I am in awe of your ability to move forward." That to the victim, who now thankfully does not have to testify because of this now guilty plea deal that he was able to strike. Some pretty remarkable things happening in that courtroom today in Belknap County. And I believe now we're going to get a look at weather.